In Hillam, a 2024 Utah divorce appeal, $350,000 in marital stock options sit inside an irrevocable trust the divorce court refused to pierce. Does the husband who funded the trust still owe the wife her share of those formerly marital assets? Only through dissipation as a credit against the marital estate, not a claim against the trust. But the trial court rejected it, and reversing that on appeal means clearing one of the hardest standards of review, abuse of discretion. Join us to see how it litigated. I'm Kelly Lise Murray, and this is Wealth Litigated Briefly, delivering all the drama of true crime without the blood. We break down actual court cases that impact your professional practice and your clients' wealth outcomes. Let's gavel in. Law engineers outcomes two ways: the law you include and the law you leave out. The Hillam appellate result was based on both. The law wife left out was unpreserved, barred on appeal, and with it the primary path to piercing the irrevocable trust. But one legal Hail Mary remained from the law wife included: dissipation. The Hillam story, deception, divorce, dissipation, starts with a Nevada irrevocable trust and $350,000 in marital stock options the wife was told were transferred for marital tax planning, until the divorce 4 years later. The Hillam divorce has three stakeholders: the husband as the named settlor of the irrevocable trust, the wife as merely a beneficiary, and the trustee of the irrevocable trust, the investment trustee, who litigated on behalf of the trust. The trust included Nevada law for situs and choice of law. For purposes of the divorce, Utah law governed enforceability and administration of the trust. The beneficiaries were identified by their first and last names, including the settlor spouse as of the signing of this trust instrument, with a very specific caveat. If husband and the husband's spouse divorce after the date of this trust agreement, then as of the date the divorce is effective, she shall be deemed to have died on the divorce's effective date. I'm not using their names, but the actual provision included the wife's first and last name, spelling out that as of the date of any divorce, she would no longer be a beneficiary. Putting this into context with the Hillam timeline, they were married in 2000. Between 2001 and 2005, they had 3 children. In 2010, the husband is employed by a particular company that offered additional compensation through stock options. Put an asterisk on that. There's a footnote in the Hillam opinion pointing out that the actual compensation were not stock options. It's just the terms the lawyers used in the case. In late 2012, husband and wife agreed there were marital difficulties. Around that time, the husband approached a lawyer to consider drafting either a postnuptial agreement or a trust. The postnuptial agreement was never created. The irrevocable trust was. The wife did not have separate legal representation. The wife did not read the trust instrument. However, unlike other cases we've covered on Wealth Litigated, she was given the opportunity to have read the trust instrument. In November of 2012, the husband signs the irrevocable trust instrument and he funds it with $350,000 in marital stock options. Those options are titled in his name only. They're marital because they were earned during the marriage. The wife in Hillam does not separately contribute assets to this irrevocable trust. About 4 years later, January of 2017, the husband files for divorce. 3 years later, in 2020, the trustee of the irrevocable trust files for summary judgment, and the husband renounces his interest as a beneficiary of the trust. The trial court grants summary judgment for the trust. It is held to be a separate non-marital asset, and the formerly marital stock options are excluded from equitable distribution. In December of 2021, the trial court signs the supplemental decree. It is the third version of the divorce decree. The appellate ruling is released in July of 2024. The Utah Court of Appeals affirms in part, reverses in part, and remands. The irrevocable trust, held as a separate legal entity and its assets excluded from equitable distribution, follows a straightforward path. But the wife's best legal arguments were excluded at the trial level, and that matters on appeal. Unpreserved, that's the term the Utah Court of Appeals uses for arguments not raised at the trial level. But in Hillam, it takes it one step further. It's not just arguments that were omitted, it's legal issues, including necessary statutes that were not cited by wife's lawyers. As a result, 2 out of her 3 issues on appeal were not reviewed on the merits because they were unpreserved at the trial level, never raised at the trial level. The first of these is creditor reach. This argument is based on a specific Utah statute. Although wife's lawyer cited the Dahl case, DAHL, a 2015 Utah Supreme Court decision that we covered in episode 107 on Wealth Litigated, citing the case did not specify the issue. Failing to cite the statute resulted in it being unpreserved at the trial level, which prevented the wife from winning on that at the trial level and also blocked it from substantive review on appeal. Second is the public policy argument, and this was detailed in the Dahl case. The wife in Dahl won on the public policy argument, and for the wife in Hillam's lawyers to have missed this is a big lawyer mistake. To summarize, an irrevocable trust that is valid may still violate Utah public policy, which favors the division of marital assets. That was fully litigated in the Dahl case. The Hillam divorce litigation didn't start until 2 years after the Dahl case decision was released by the Utah Supreme Court. It should have been fully briefed at the trial level. Because it was also admitted at the trial level, it was not reviewed on the merits on appeal. Hillam is a primary example of issue preservation. It's not enough to make arguments. The issues themselves need to be preserved in the pleadings, amended pleadings, motions for summary judgment, and if these issues go to trial, they need to be raised before the trial court in order for an appellate court to even consider them on the merits. The third argument raised by the wife, the Utah Court of Appeals specified may have been close to being unpreserved. The appellate court went ahead and ruled against the wife, assuming it was preserved. That's how she lost on all 3 arguments, and the irrevocable trust remained irrevocable and outside the scope of equitable distribution. That left one legal Hail Mary on appeal for the wife: dissipation. Because the trial court denied dissipation at the trial level based on law, the wife's lawyers included, the appellate standard of review is abuse of discretion, one of the hardest to overturn. Dissipation is generally a set of common law rules based on case law precedent. Each state may have a different number of rules. They may phrase them differently. Utah has 5 factors. All 5 are not needed to support a finding of dissipation. In the Hillam trial result, the wife lost on all 5. The Utah Court of Appeals held that 2 of the 5 were affirmed, meaning 2 of the 5 did not show dissipation. 1 of the 5 was a close call, could have gone either way, and then 2 of the 5 were reversible because those 2 factors showed abuse of discretion and may tend to show dissipation. The first 2 factors were affirmed on appeal as not dissipation in Hillam. Factor 1 is the trust's purpose. Because husband, wife, and the family CPA testified that one of the purposes of this irrevocable trust was tax efficiency. That is a valid purpose for an irrevocable trust, and that did not show dissipation. Factor 2, historical practice. Even though husband and wife had never created irrevocable trusts for these marital stock options, the trial court interpreted this broadly in favor of the husband, that by prepaying taxes and being tax efficient, that showed a historical practice. Factor 4 was affirmed. However, the appellate court specified that this issue could have gone either way, and that shows the power of a divorce court's discretion. Even if the appellate court would personally rule differently at the trial level, that does not show an abuse of discretion, and in that instance, they have to affirm. That's why the appellate court affirmed on Factor 4. Factor 4 concerns the timing. Here, the irrevocable trust was formed at a time of marital discord. At the same time that the husband investigated irrevocable trusts, he was also investigating postnuptial agreements. The divorce trial court held that because this marriage had similar phases of discord even before that moment in time, that as a result, timing did not show that the creation of the irrevocable trust was influenced as a pre-divorce protection for one of the 2 spouses. The appellate court specified that factor could have gone either way because the divorce was filed by the husband 4 years after the creation of the irrevocable trust. Factors 3 and factors 5 were reversed. And this is where Utah uses not just different terminology, but actually different standards that you see in other states. For abuse of discretion, Utah specifies that incorrect interpretation of law is an abuse of discretion. That's how the Utah Court of Appeals phrases it. These final two are reversed from an incorrect application of the law. Factor 3 is the magnitude of the deduction from the marital estate. Well, this irrevocable trust had $350,000 in marital stock options that were excluded in divorce from the marital estate. Isn't that a sufficient magnitude? Trial court held no, because those marital stock options, according to the trial court, still existed. The trial court held that because they were now transferred to an irrevocable trust, they weren't dissipated, they weren't gone, they just were owned by a different entity. And that meant those assets were not wasted, which is a traditional view of dissipation in divorce. The appeals court held that that was the wrong frame and the wrong legal standard. Relying on the Shepard case, where dissipation occurred when a spouse seriously depleted the marital estate, not when a particular asset is depleted in the abstract. For the appeals court, the reframed question is not do the stock options still exist, it's whether the marital estate itself was depleted from the removal of those stock options. This legal error was an abuse of discretion. Factor 3 was reversed. Wife prevails on that issue. This is the example the Hillam Court of Appeals uses to illustrate the reframe of Factor 3. Quote, a spouse who surreptitiously transfers all the funds from a joint bank account into an account only that spouse controlled. Has the marital estate been depleted? Yes, even if the money itself still existed within the other non-marital account, close quote. On remand, the trial court has to reassess. This doesn't mean the wife will win on remand. It means the trial court has to review Factor 3 to determine the magnitude of the loss of $350,000 in marital stock options. Factor 5, obstructive efforts. And this is one of the main legal takeaways to cite the Hillam Court of Appeals decision for. The trial court held that there was no obstruction because the wife herself didn't take advantage of the opportunity to read the trust instrument before signing it, for example. The trial court was looking for affirmative acts of obstruction by the husband, and those did not occur. On appeal, the Utah Court of Appeals reversed, specifically holding that obstruction is not merely affirmative acts, even though it may often be affirmative acts, that obstruction does not require affirmative acts and may be shown through omission. The appellate court held that by wife's lack of understanding that she would be disinherited from this family trust, she viewed it as a family trust for tax purposes, the fact that she didn't know she would be disinherited upon divorce, and that those $350,000 in marital stock options would be excluded from the marital estate in any divorce. Those were held to be omissions that could support dissipation. But it's not a guarantee on remand that the wife will prevail because, again, this goes back within the trial court's discretion. The Court of Appeals specified, quote, it sometimes might be possible for a spouse to impede or hinder the other spouse's awareness of something, even something important, through half-truths or targeted omissions alone. Close quote. On appeal, the wife wins on dissipation, but only 2 out of the 5 factors. As a result, the irrevocable trust remains irrevocable. On remand, the trial court is ordered to reassess factors 3 and 5. It is no guarantee that either or both of those will be reassessed in favor of the wife, and if they are not, she will still lose on dissipation. The bottom line of Hillam is that the same transfer of marital assets to the same irrevocable trust can be both valid and enforceable tax planning and dissipation. The Hillam takeaways for lawyers are very specific and very important. Outcomes are engineered with the law included and the law excluded. That includes procedural rules and substantive issues, not just arguments. Citing a statute, for example, should be the priority because Hillam shows that citing a case that's sort of cited a statute does not preserve the issue. Anything unpreserved at the trial level is invisible on appeal and will not be resolved on the merits. In Hillam, dissipation was the inverse of the attempts to pierce the irrevocable trust. The trial court ruled against the wife, but because all the law was presented at the trial level, it could be reviewed on appeal. Takeaways for advisors and lawyers: this conflict of interest. When in the Hillam timeline would a conflict of interest have arisen when one spouse takes marital assets and transfers them to an irrevocable trust as the sole settlor? Could one financial advisor still represent both even before one files for divorce? One recommendation is that each spouse have independent legal counsel. As an irrevocable trust that is valid, enforceable, and outside of equitable distribution may also be dissipation, or as in Dahl, against public policy, maybe is not wealth protection and may become wealth litigated. Thank you for joining us.
This is Wealth Litigated, where the real courtroom battles we analyze today are your roadmap to stronger asset protection and better wealth outcomes. Follow us on your favorite podcast platform or subscribe on YouTube so you never miss a weekly episode. Questions or cases? Visit wealthlitigated.com/questions. This show is for informational and educational purposes only and does not constitute legal, tax, or financial advice. No attorney-client relationship is formed. Consult a qualified professional for advice specific to your situation and jurisdiction. Wealth Litigated is now adjourned.